Did you hear about the divorce where child support was waived, or the kids who picked which parent they were going to live with? These stories come from confusion. They're just not true, but they've been passed on to the soon-to-be separated from friends and families for years. Well, here to dispel family law's urban legends, we've got Bud Kluick and Kim Kirkpatrick. So set us straight, guys. I guess there's tons of these that are floating around that we just have kind of taken to be fact.
Right, Renee. Well, first we want to talk about what the original references of what urban legends are. There was a movie a few years back called Urban Legends, and it's all those stories about the bloody hook in the door and the babysitter who gets the call, have you checked on the children, and Mary hitchhiking home from the prom most people have heard these, or particularly then Boy Scouts or Girl Scouts and sitting around a campfire, they've heard these urban legends. But there are also urban legends involving family law, and one of them is that if you have 50-50 custody, neither party has to pay child support. It just ain't true. It's a legend. People pass it on, but it's not true.
Now, to me, when I hear that, I thought, well, that might make sense because you're splitting up the time, but why legally doesn't that work?
Well, because the only way that it would work is if you actually have exactly the same income, and then there would be no child support. It does reduce the child support, but as long as one party is making more money than the other, there will be some child support paid. The reason it reduces the child support, Renee, is that time share, or how much time both parents spend with the child, is one of the factors that goes into the algebraic formula involving child support. There are other factors, obviously, mainly the parents' income and how much time they spend with the kids. And the theory there is that if the child is with you, or the children are with you, you're spending money on them directly. You're taking them to the restaurant, you're taking the ball game, whatever you're doing with them. And so if you're spending money on them directly, you get a break and have to pay less child support. So it does affect the child support, but it's never zero. Unless, again, the parents are making exactly the same income, which almost never happens.
Good to know. And some other urban legends out there, Kim.
Well, on those same lines, waiving child support. We'll sometimes hear of families who sit down over the kitchen table and work out the details of their divorce, and they may say, well, we're not going to pay any child support to each other. And there may be another component to that, like, well, you're going to keep this stock portfolio and I won't pay you any child support. And they have a deal, everybody signs it, everybody's happy, and then something happens down the road, some unforeseen financial circumstances, and the one parent goes into court and files for child support, and the other parent goes, wait a minute, we had a deal. So you can't waive child support and have it be a forever thing.
Also, annulments. There's some urban legend around this.
Well, I think that there, and I don't know if movies are to blame or what, but there seems to be this idea that if you get married and you have not consummated the relationship, that you can get the marriage annulled. And that's not true. The consummation has nothing to do with whether or not you'd be entitled to a nullity. A nullity or an annulment basically is going to require some finding of fraud, is something that maybe procreation could become involved if the two of you had discussed having children and one person actually was unable to have children and knew that and didn't share that information. That would be grounds for a fraud, but simply not having a wedding night, so to say, is not grounds for an annulment.
But I learned something fascinating today. I always thought that there could be an age in California where a child could decide which parent he or she wanted to live with, and you're saying that's not true.
That would be an urban legend. There is no age. The older the child is, the more that the court has to take consequence or pay attention to what they say. They can express a preference, but it's always up to the judge. It is never up to the child.
You have a free, a special offer today.
This is not an urban legend.
No, this is true.
Yes, if they hire us in a case that would likely go to court, may go to court, does go to court, the first hour is free. We will no charge them for that first hour. Now, if they're just hiring us to do a document preparation, then that's different. But if it's something where we're going to go to court, or it's likely or possible for us to go to court, then that rule governs, and we will no charge them for the first hour.
And quick mention about something you're offering tomorrow.
And that is?
That is, it says April 22nd, a free live, oh, no, I'm sorry. That is not, you are not offering that tomorrow. That is
But we offer a lot of things,
yeah.
Renee.
Holy cow. I am looking at the wrong notes. I am looking at something else. But thank you guys so much for coming on today. And urban legends will get those completely out of our vocabulary. And I'll straighten myself out, too. San Diego Living is back right after this.